I was Jerry Cohen's student in 1970. At that time, he changed my life, as he's changed many people's lives. And more particularly relevant here is he was the founder of the U.S.-Asia Law Institute in 2006. And I'm going to introduce this panel. I'm going to introduce Catherine. But first, let me say one thing about the U.S.-Asia Law Institute and its activities. My field is property, and comparative law, both in China and Japan. So the USALI's activities have been mainly in criminal justice, so I haven't been intimately involved in them, but I have attended some. And this is exemplary, this is illustrative of USALI's exemplary way of dealing with legal reform. We're presenting 3 different jurisdictions, or USALI is presenting 3 different jurisdictions. And as we'll see, the learning will go in 3 different ways. And to the extent that I've been involved in activities in China, that's always been the way it is, and that's one of the things that I'm very honored to be asked to introduce you. So I will introduce a couple of people. First, Ira Belkin. Ira, if you will stand. Ira came as the executive director in 2012, just as Chung Guang-Chung was leaving. And he has been, I won't say replaced, but there's a new executive director now, Catherine Wilhelm, who came this year, and she will continue the introduction of the program. Thank you very much, and enjoy the program.
Okay, good morning. So I'm going to set the stage for our program this morning by briefly explaining first what wrongful convictions are, for some of you who may not be criminal justice focused, and also why the U.S.-Asia Law Institute has a program on wrongful convictions. So in a wrongful conviction, a defendant has been convicted and sentenced, and he or she may have confessed and may have pleaded guilty, but is in fact factually innocent. And in the United States, we've had 367 persons exonerated since 1989 after convictions on the basis of DNA testing. We've had more than 2,100 others who have been exonerated on other bases. So we have a lot of wrongful convictions. These exonerations have been enabled mainly by scientific advances, DNA testing most obviously, but also advances that have undermined confidence in key aspects of forensic science, for example, ballistic testing, and have started to cause courts to doubt the reliance on these forensic tests, and also advances in social science that have showed us that some of our previous assumptions about people's behavior were not true. For example, some of the social science around false confessions is fascinating. We used to think that nobody would ever confess to something that they didn't do. And what we've found, in fact, is that under certain circumstances, many people will confess to things they didn't do. And those circumstances don't have to go as far as torture. Simply stress, isolation, very lengthy, exhausting interrogations, and high-pressure tactics by the interrogators can cause what we call police-induced confessions. And all of these combined can add up to wrongful convictions. We see some of these factors playing out in the Central Park jogger case that happened here in New York City in 1989. And we'll have a couple of people who were involved in that case speaking in our second panel who can explain how that worked. So to learn more about wrongful convictions and the different factors that can help create them, I would suggest you go to the website of the Innocence Project. Last Wednesday, October 2nd, was World Wrongful Convictions Day, and they put up a number of short videos that explain different factors that come into play in wrongful convictions and the new social science that is helping us to better understand the roles of confessions, interrogator bias, how police lineups work, and so on. So the U.S. Asia Law Institute began its wrongful convictions program in 2015 in a very modest way. We invited Barry Scheck, the founder of the Innocence Project, and Bing-Chung Lo, who is the founder of the Taiwan Innocence Project, to come talk about their work in a series of lectures at mainland Chinese universities. And we did that because we knew that judicial authorities in mainland China had begun to overturn wrongful convictions there in a rather dramatic way. A couple of cases where the supposed victims of murders appeared back in their hometowns. They came back from the dead. It was obvious that the people who had been convicted in those murders were innocent. And so we thought there might be interest in the topic. We found there was great interest, and this led us to develop a full-blown program. We have a brochure out by the desk in which we describe the history of our program. Let me grab a copy of it. And so if you're interested, we explain here how we develop this year by year. And one of the key features is that every fall we have an intensive, immersive workshop for lawyers, prosecutors, judges, and research scholars from various jurisdictions in East Asia to come here to NYU and spend time with us discussing and learning about what has been going on in the United States to try to prevent and to redress wrongful convictions. This year's program began September 23rd. We had about 20 people from mainland China, Taiwan, South Korea, Japan, and Vietnam participating in the program. We've visited defense lawyers. We've gone to state Supreme Court in the Bronx, federal court, the Innocence Project, of course. We've visited the New York City Office of the Medical Examiner and had various social scientists and police interrogators come to speak with our group about their findings and their work. So today is the final day of the workshop, and we're doing something new. We are holding a public event because we wanted to give you all a bit of a taste of the kinds of conversations that we've been having in our small group about how wrongful convictions play out in different societies under different criminal jurisdictions. We wanted to help you to see what we enjoy most about these kinds of cross-jurisdictional conversations, which is that by talking across different systems, we come to understand our own systems better. Frequently, when we talk about the outcomes of criminal justice in other systems, we assume that those outcomes are completely defined by factors specific to the legal jurisdiction. But what we find when we talk about wrongful convictions is that there are a lot of things that are simply a result of human nature. And some of the policy approaches that have been taken in one jurisdiction can be adapted and adopted in other jurisdictions, which is to say we can learn from each other. So, for example, in these last few weeks, we have been talking within our group about various kinds of responses to the problems that I've described, things like double-blind lineups for when police try to ask witnesses to identify a suspect, video recording of police and prosecutor interrogations from start to finish, and then disclosing those videos to the defense, asking courts to bring in neutral experts to examine and opine on evidence, the validity of evidence, various measures that can help to address some of these problems. There is no silver bullet, of course. And in these conversations about cases and about approaches and solutions, it's also useful for us Americans to realize that we're not universally in the lead in resolving things. So I learned this last week that in Taiwan, police and prosecutors are required by law to videotape the entire interrogation process, including interrogations of witnesses, and to make the video available to the defense upon request. And that's more than we do. I think half of the US states have mandatory video recording requirements for interrogations, but not even for all cases, all kinds of crimes. So we have a lot we can learn from each other, and I hope that in today's program you will find much to learn and also to be inspired by. And now I'm going to hand it over to USALI research scholar Alan Clayton Green, who's going to have a conversation with the Taiwan Innocence Project's Chen Yuning. So if you would come up. And to set the tone for the conversation, we're going to just play a very short trailer from a documentary that the Taiwan Innocence Project made about one of their cases.
这案子其实没有任何的直接证据证明郑姓者杀警，也感谢检察官为本件提起再审。这个在我国的司法史上已经创下一个非常重要的里程碑。郑姓者无罪。
照片证件没有，因为我起郑姓者章就绑出来了。
来，对，眼睛张大大的，眼神放松一点，放柔一点，对。
你看到囝啦，那变唔来要对你讲起啊？
我无在中国，
无在中国。
我被判死刑确定，我家人也是很伤感。
Good morning. My name is Alan Clayton Green, and I'm a research scholar here at the US Asia Law Institute. What we've seen there is just something quite extraordinary. It's a man who was on death row. He was in prison for 5,321 days. And it's a documentary that's about his first 48 hours when he was released. Firstly, I'd like you to just give a quick round of applause to our first guest, Chen Yuning. She's the first director of the Taiwan Innocence Project. She's been a lawyer for over a decade and someone I've admired for a long time. So yeah, welcome, thank you.
Thank you.
Yuning, you know, there's this phrase that it takes a village to raise a child. And one of the things that I find so impressive about the Taiwan Innocence Project is you've only been around since 2012, and yet you've already received, 8 exonerations. This is an extraordinary effort when you consider, in the Innocence Network, it's quite often the case that an Innocence Project can take between 5 and 10 years to achieve its first exoneration. Could you tell us a little bit about the village that is the Taiwan Innocence Project?
Well, good morning. I'm Yuning Chen. I'm really honored to join the discussion today on behalf of Taiwan Innocence Project. I'm very thrilled to be here today because the last time I was in New York City was in 2012. We're about to begin Taiwan Innocence Project. So I came to New York City to visit New York Innocence Project. And the first piece of advice that Maddie gave us is that Innocence Project is a trademark. It's not something that you can use whenever you want. So you need to be our member. So lesson learned. So ever since then, we've tried very hard to work up to the standard set by the Innocence Network. And we've become a member of Innocence Network since 2015. And it's really my pleasure to be here again to share with you the work we've done in the past 7 years and the development we've achieved. You mentioned about the village, okay. Well, first of all, there are 6 full-time staff in our project. they're certainly in our village. 3 of them are lawyers, 1 paralegal, and because we have a very huge caseloads, so a lot of our work are heavily relied on lawyers doing pro bono for us. I myself, as a lawyer, doing pro bono for Taiwan Innocence Project, and they are either lawyers. They are running a small-sized firm, or solo practitioners, so that they can be more flexible with their time. And so what TIP do is that after we decide to take a case, we'll allocate the case to a experienced or many experienced litigators, and we'll keep a close management of the daily practice of that case. So there are, I think, I do not have the specific number, but there are many lawyers working pro bono for us. And other than lawyers, although we are not affiliated with a law school like many Innocence Project in the States, but we have corroborated courses with at least 2 prestigious law schools in Taiwan. So we have law students join our work. And we also work with scholars and experts in different fields. We have a toxicologist here with us today. She is an expert working in the DOJ lab. She's the one we go to if we have any toxicology-related cases. And we hold an event, it's called Innocent Tuesday. So we invite all kinds of experts to give a talk. For example, psychiatrists talking about PTSD, or fingerprints analysis expert explaining the techniques of fingerprinting analysis. And by inviting them to our project, we have this mutually knowing each other things going on, that they will know more about our work and will be more familiar with the things that they are doing in their field. So yeah, there are a lot of people in our village, and currently we are trying very hard to include prosecutors and judges. There are also participants in the judicial system to join the village. I think we're doing a very good work in that aspect, given that there are 2 death row cases, or the retrial petitions were filed by the prosecutors. So we tend to keep a very benign relationship with them and to address the wrongful convictions together with them.
One of the things we think a lot about here at the US Asia Law Institute, as we try to sort of nurture and support other organisations, is, you know, some of the differences that exist in jurisdictions when it comes to wrongful convictions.
Right.
Can you just talk a little bit about how do you get to an exoneration in Taiwan? You know, you mentioned something to me when we were chatting earlier about the 3 exonerations rule.
Right.
Can you just talk a little bit about the process to get an exoneration in Taiwan?
Okay. To get an exoneration in Taiwan, there are mainly there are 2 procedures. One is retrial, and it can be petitioned by either defendant or defense attorneys, or by prosecutors. And there is another procedure called special appeal. And to address, the special appeal is to address serious violation of law or due process. And it can only be brought by the prosecutor. So most of our cases were overturned by the retrial procedure. Mhm.
And one of the things that, you know, I've been thinking a lot about, and today's going to be exploring in depth the Central Park 5 case, you know, is the extent to which some of these cases have echoes in other countries. You know, there are these similarities that you see appearing over and over again. You know, we were talking a little bit about the Su Jianhe case. Could you tell us a little bit about that case and kind of what you see as some of the echoes of the Central Park jogger case in wrongful convictions in Taiwan?
Well, although that we do not have very obvious race issue in Taiwan at this moment, at least, because we are having many marriage immigration from Southeast Asia in the past 2 decades. So there might be. But still, I'm surprised, or when I watched the Central Park 5 documentary, I'm still surprised by the similarities shared by the 2 cases, Central Park 5 and Su Jianhe. Su Jianhe is called Xizhi trial case in
The
Taiwan.
Xizhi trial?
Yeah,
Okay.
the Xizhi trial. Xizhi is the district name, and the trial means that there are 3 defendants in that case. And the case happened in 1991, I think.
Yeah, that sounds right.
Okay, you did your homework.
Yeah.
Thank you. Well, 3 young men in their early 20s, they were falsely indicted and convicted for robbery and manslaughter. And the causes of their wrongful convictions are coerced confession and very flawed forensic science. And in the Xizhi trial, I'm not going to go into the details, but one thing that I'd like to mention is that Catherine talked about our law of requiring the law enforcement to record the whole interrogation procedure. The law was passed in 1997, and the Xizhi trial case was one of the factors that push for the passage of the law.
And it was also a case that was covered by a documentary, right? The documentary was a key part of that case. I was fortunate to meet Chen Xingzi last year during the Asian Innocence Network conference. And one of the things that really struck me was how beautifully connected all of the exonerees are, you know, at Taiwan Innocence Project. You told me you have some traditions about that you kind of use each time someone's exonerated. Could you tell us a little bit about that?
Okay. The Chen Xingzi case, he was wrongfully convicted for murdering a police officer, and his case happened in 2002. And Chen Xingzi's case is the first case we took after we began this project. And many of our defense attorneys had been working on the Xizhi trial case before the beginning of our project. So the Xizhi trial case ended in around 2000, I think it's 2013 or 2012. And on the date that they were fully exonerated, instead of going home with their family, the 3 exonerees, they decided to visit Chen Xingzi. He was in custody in the Taichung Detention Center. He's not in the prison. He was not in the prison because he got a death row sentence. So he supposedly has no time. That there's no time that he has to serve. So they visited him, and I think it's a very useful way to show to the public that the damage can do to people who suffer from wrongful conviction. And the message they were passing to the public is that they want the public and all participants in the judicial system to keep on working on the case of Zheng Xinze. So it then becomes a tradition for our exonerees to pay visit to one another and to attend each court sessions of the exonerees. Yeah.
And Zheng Xinze is now growing rice and selling his own brand of rice. Is
Yes,
that right? Yeah.
yes.
So that's very
Yeah.
very cool.
Yeah.
You know, let's just shift the conversation a little bit. You know, we're in kind of prime time for exonerations in Taiwan at the moment with the DPP in power, and you're kind of founder, Lo Bingcheng now being a special minister in the government. You know, another interesting aspect of this wrongful convictions work is how often it gets sucked into the political maelstrom and the media maelstrom. Could you talk just a little bit about kind of how the politics influences the work of the Innocence Project in Taiwan?
Well, from the very beginning of our work, thanks to our colleagues in the States, we realized in the very beginning that it's very important to get involved in the politics. So our second and current director, he used to be a legal assistant for a congresswoman. So that's why we chose him to be our director, because he knows how things are done in the parliament. And the first, there are two structural reforms that we have done so far, legally speaking. One is that one is the amendment of the retrial law, because the threshold of the law of the old law is way too high for us to get an exoneration. And the second is the pass of a post-conviction DNA Act after our first successful DNA exoneration. And these work has to be done by, well, to be honest, it has to be done with someone who liaison with the parliament. And I think we haven't been encountered much difficulties in that area, is because that although there might be some disagreements in many issues, judicially, for example, the death penalty is a controversial issue in Taiwan. But when it comes to wrongful conviction, it seems that we can all agree that we should not put someone who's innocent in jail. And this kind of topic can be easily sold by the media or by the legislators to their voters. So, so we've been having a very smooth ride along the legislation process.
Thank you so much. So one of the things that we're thinking always about here at USL is kind of where to next. And I see we've got just a couple of minutes left, but I wondered if you could talk about sort of the future of Taiwan Innocence Project. I know, and also thank you, by the way. I know you're probably super jet lagged. You just flew over specifically for this event. But if you could just tell us a little bit about where you see the project going next.
Okay. I think I can. Well, first I'll speak internally. There is something that we want to work on is, unlike some of the projects in the States, which only do DNA cases, we do both DNA and non-DNA cases. And DNA cases are clear-cut ones. You're either innocent or not. But for non-DNA cases, it takes us a lot of time to screen the case to see if it fits the criteria of actually innocent and whether there is flawed forensic science or serious violation of due process. So it always takes a long time, a long debate for us lawyers to discuss whether to take a case. So sometimes we would ask a lawyer to take the case and to petition for more files before deciding whether to take it, or we need to consult many experts in that field before deciding, and many cases are still lingering in our screening process. So there's something that we are trying to improve. We don't know how at this moment, but it seems that in terms of the allocation of the resources, it's taken way much of our time and effort in doing this. And externally, as I mentioned, we passed the Post-Conviction DNA Act in 2016. But after the act passed, there aren't as many cases as we expected, mainly because that the chain of custody and the law of preservation evidence in Taiwan are not sufficient enough, are not substantial enough for the evidence to be kept. So this is something that we will be working on in the near future.
Yoning, it's been absolutely wonderful to speak to you. I know our audience probably have some questions, and you'll be back on the stage later to answer them. But thank you so much for this great honor of talking to you today.
Well, thank you so much for the opportunity, and I welcome all the comments and remarks. Thank you.
Thank you. So with our next panel, we're going to be switching gears and shifting back to the United States. USALI Senior Research Fellow Ira Belkin is going to lead a conversation with two guests who are connected with the Central Park jogger case. Do you want to come up now? Do we have everybody here? Yes. Okay, I'm going to let Ira make the introductions of our guests, but first, again, to set the tone for the conversation that's going to follow, we're going to show you the trailer to the 2012 PBS documentary, Central Park 5.
So I want to welcome Sarah Burns and Kevin Richardson and thank them for joining us. We're going to get into the film and the case in a second, but I have to acknowledge a few people here. First, Professor Rachel Barkow, whose center is co-sponsoring our program, but also folks from the Innocence Project. Maddie's already been mentioned, Chris Fabricant, and Sarah Chu. There's no organization more generous than the Innocence Project. We have leaned on them for the last 4 years for our program, and they've always accommodated us, and Chris even came to China with us last year. Also, one more person, he says there too over here from Innocence Project. Okay, thanks. And those of you who are familiar with Saul Cassin's voice, heard him in the intro. Saul, could you just stand up? I just want to acknowledge you. Our leading expert on false confessions, Professor John Jay College, who's also generously shared his time with our program. So I want to get into the case a little bit, and I'm a little nervous because I'm a great admirer of both of you. Sarah, I want to start with how the this whole project started, because I think the story there is quite interesting. How did you first learn about the case, and how did you decide this was something you wanted to dedicate a lot of your time and energy to?
Yeah, thank you, and thank you for having me today. When this first happened, when the crime occurred in Central Park, I was 7 years old and not tracking it, not aware of it at the time. I lived in rural New Hampshire. I did not see the newspapers. I was not aware of it. And so for me, I first learned about it when I was in college, and I was majoring in American studies and focusing on African American studies, and I was thinking about law school. And so I got a job the summer before my senior year doing research and sort of paralegal work for a civil rights lawyer here in New York. And this was 2003. And so the exoneration had just happened in December 2002. And this lawyer, Jonathan Moore, was working on what would be filed later that year, the complaint in the civil suit in this case, in Kevin's case. And so I did a little bit of research, I helped out with that, and I met Kevin and Raymond that summer, so more than 15 years ago now, and became really fascinated by the case, and I didn't know it before, and so I ended up writing my undergraduate thesis that following year about the racism in the media coverage of the case. So I did a kind of study of the daily papers in New York and the animal language and imagery that was used to depict the Central Park Five, it was just called the Central Park Jogger case at that time. But this language like wilding and wolf pack, savage, and the kind of historical context for language like that. And, but that was a very academic work. I mean, I was an undergraduate, but it was it was just studying the newspapers, a lot of microfilm research. And so when I finished school, I was still thinking about law school. I went back to work for the lawyers and on different cases, but I couldn't let go of this story. It felt like a story that people didn't know and should, and a story that I wasn't finished trying to tell. And so I decided I took the LSAT, but I decided instead of going to law school to write a book. And I didn't know how to do that. So I just had to figure it out as I went along. And I spent 5 years researching and writing a book about this case and the wrongful convictions and how they'd happened and what the factors were and the history around it and context. And for me, documentary filmmaking is the family business. And so I hadn't necessarily planned to become a documentary filmmaker, though obviously I'd grown up with it. And so once I started writing the book and telling this story, it became very clear that a documentary film was perhaps an even better way to tell the story. And that was important because it allowed us to sort of hand the storytelling over to Kevin and the other guys, and just not just have me interview them and write about their experiences in the book, but to actually put them on screen telling their own stories. And that was clearly the best way to tell this story. And so the book can have more detail about the trials and exactly what happened. But the film, I think, is a really powerful document of what happened because they can explain for themselves what they went through, the impact on them and their families. And that was a really extraordinary experience for us. So that the film came out in 2012 and 13.
Yeah, so for any students that are here, be careful what you choose to write about. You never know where it might lead. So Kevin, I want to ask you, after these honorations, I could understand if somebody didn't want to revisit what happened and tell their story, but how did you meet Sarah, and how did she earn your trust so that you'd be willing to share your experience with her and with all of us?
Good morning. Wow. First of all, thank you. It's always an honor for me able to speak about my story and just in general about what I went through. These are the times when I really don't feel that good, but I'm a little under the weather. But when it's about things of this nature, you just have to push through and do it. So I'm here. Sarah. Sarah has become family. She's a sister. And at the time when I met Sarah in the law offices, myself and other brothers, we really didn't trust anybody. As you may know, anybody that was around during that time, we didn't trust media that much, and anybody that was dealing with that. So I remember myself and Raymond, we were speaking about Sarah, and we said, well, she's around the lawyers, so we think she's, has some good intentions. So we met each other in Starbucks, actually, and we had some coffee, and we wound up speaking for quite some time. And it was just the connection that we felt, and we felt comfortable with it. And it started from her speaking about how she's passionate about our story, and she wants to bring it out, and she wanted to start in a book. So we felt very familiar with her. And after that process, she started to do the book, and then she rung up maybe doing a film, a doc. And she said, my father will be on board too. And we said, oh, who's your father? And she said, oh, Ken Burns. And we know him, but we really didn't know him that much. But the rest was history after that. It was 15 years ago, and now we're here today. And I would do anything for her whenever she asks me to be a part of something. I'm with it, because during that time, Sarah and Ken and Dave, they were the first ones along the Innocence Project, hi Maddie, that really gave us that push and gave us our voices back, because at that time, our voice was loud during the 80s, but it was a whisper to the world, because we felt nobody was listening, even though we were screaming that we were innocent. So she gave us our voices back at that time.
I think one of the lines in the film that stays with me is, I think one of the people you interviewed, the historian, who says, at the time, 1989, when this happened and the trial, it received such a media frenzy and so much attention. And when the exoneration came, never got anywhere near the attention that the original case got. I want to talk a little bit about the interrogations and false confessions, because that is a big part of the case. And I want to give you both a little background. I don't know if I've told you. As Catherine said, we work mostly in Asia with Asian legal experts on legal reform, and primarily in China, where there's a confession in almost every criminal case, and police don't feel like they've done their job if they haven't gotten a confession. So we've been focused for many years on trying to persuade law enforcement people in China and courts that you really have to be careful with interrogations. And the confession evidence, as you write and as you experience, is so powerful, it overcomes everything else. In your case, even, there was DNA evidence exonerating you before the trial, but it wasn't until someone else confessed that you were actually exonerated. So when I saw the film for the first time with a colleague from the US Asia Law Institute, we came out and we looked at each other and we said, we have to bring this film to China, because the film shows how an innocent person might confess to something they didn't do. And I have to confess, I was a prosecutor for many years, and if I had a confession in a case, I would argue to the jury, why would an innocent person confess to something they didn't do? So I think it's a common sense kind of reaction, and I think your film and your story explain that. So I wonder if you could, maybe Kevin, if we could start with you. What was your experience like? Can you explain, a 14-year-old boy brought into the police precinct, how did you end up, and you didn't, we use the word confess, but in fact, that word is misused all the time to cover a lot. You made some statements about being present that weren't true, but those were the statements that got you in trouble, even though you didn't admit to actually participating in the sexual assault. But how did that process even work, that you went from not being part of this, not knowing anything about it, to providing the statements that ended up being used against you?
Oh man, I always tell this picture for people to realize that imagine you're in a nightmare, but you're not waking up from it. And that was my process at 14 years old. You know, I literally went from Easter vacation that year, 1989, April 19th. I was so excited about being on vacation. So when you're a teenager, you have a lot of idle time, and sometimes you don't have nothing to do with it. So I remember that day just playing basketball, actually. I lived across the street from Central Park on 110th Street, which is Central Park North, which they call Harlem North now. I remember going from my house to the park because I was curious. I seen kids, which was by my area, so I wanted to be a part of the group. From that point on, everything was a frenzy to me that I knew that I was not supposed to be in that situation and I should be home. So I was actually on my way home when I got arrested because I was scared that my mother was going to get me from not for curfew. That was what I was afraid about. Before I know it, I wound up in the precinct that night of April 19th. And originally, we were there for like rioting in the park and unlawful assembly. And we supposed to appear in family court. We supposed to have that desk appearance in family court. So at that time, being 14, I'm naive, and I'm tired. I just want to get home.
This is at midnight.
Yeah, this was later on that night, and I had school that day as well, so I was already tired. But now being in the precinct and someplace I've never been, I was never in trouble. I find myself being centered and circled by these seasoned detectives that was much bigger than me at the time, because I definitely don't look like I did 30 years ago, So I remember being so afraid, and my mother wasn't there. And you have that, your parent or guardian is by you, you feel very secure. But I felt left alone because it took a while for my mother to find out that I was in the precinct, even though she was the first parent to arrive at the precinct. But I never got to see her because the detectives, they did a game of cat and mouse, good cop, bad cop, and every time I hear my mother's voice outside, I'm thinking that she will come save me, but she couldn't find me because they would move us to different precincts and things of that nature. So going through the interrogation, it starts off calmly. They say, "Oh, you're a good kid. We know you're not gonna, we know you didn't do anything. We just want you to get home. Tell us what you know." At the time, I'm telling people that I don't know. What are you even talking about? Especially about a female jogger. So maybe hours went by. I knew it was the next day already. Interrogation's getting a little bit more intense. Detectives are getting upset because they're not getting what they want. The voices turn to physical abuse, things like that. So all I remember at that age is I need to get home. I just want to get home. So it became like a coaching situation where whatever they tell me, I would put down on paper, even if it didn't make sense. I just knew I had to write something down. And the pressure became more and more. And people often ask this question, but now they know this. Like, why would you confess to a crime? And I tell people, you really don't know until you're trapped into those four walls. And this happened to a lot of adults. So imagine kids. You're talking about literally kids, 14, 15, and 16 years old, respectively. So it's something I still deal with, but it helps me. I'm still healing 30 years later. So me speaking and traveling to universities and law firms and schools is therapeutic for me, because this is an ongoing process that myself and as well as the brothers are still going through, and it's very traumatic, you know. So, but by me going through my process and healing, I'm able to help other generations and connect with others, such as the thing that you're doing now with Asia and things of that nature, because we're dealing with the same thing. It's a global situation.
Thank you. Just so you know, of the 367 DNA exonerations that the Innocence Project has obtained, between 25 and 30% of those cases have false confessions. This is not a one-off case. It's an epidemic. So, Sarah, I want to turn to you. I'm so in awe of your doggedness and your ability to investigate and research, and you had to create a visual record of the interrogations without having, you know, a videotape of the whole process, only the last bit. And by the way, I think, Kevin, I'm right that you were arrested late on the night of the 19th, but your videotape confession was 2 days later. You were in the precinct that whole time.
Yes.
Am I right? Yeah.
Yes.
So the morning, I think 5 a.m. of the second day, which is really startling. But so Sarah, can I turn to you? And how did you, first of all, how did you figure out how they were interrogated, and then how did you figure out how to sort of show that in the film?
Yeah, that was, you know, as I was thinking about how to tell this story, I decided to start this book project. And even though it's not the first chapter of the book, the first thing I wrote and researched in working on the book was a chapter about the interrogations and false confessions, because I think for the reason that we've already discussed, it's the thing that is hardest for people to understand, to relate to say, I would never confess to something I didn't do. And that felt like I felt like I needed to truly understand how that could happen, so that I could explain it to people so that they could understand. Because without that piece of it, the rest of the story doesn't work. I mean, you can't, like, that's so critical to understanding what happened and how this happened. And so that was the first place where I started. And I looked at, I mean, I ultimately read all the trial transcripts and everything, but I also had police reports and notes and the things that were presented at trial of those, you know, documenting those interrogations. And that the thing I'd done that one summer working at the law firm was actually taking a lot of those documents and creating a timeline of who was where when and who was interrogating whom at what time in what precinct and all of that. And so I had already started to like piece together this, just the timeline of what had happened, how long these interrogations had been, who else. I mean, there were 25 or 30 kids in the park that night. Police talked to most, if not all of them. But it was only 5 who ultimately were tried for this crime. And so that's also a really interesting question. Why not these other kids? What was it about, you know, these kids that made them more vulnerable to giving false confessions as opposed to other kids? I mean, some of the other kids, in a couple of cases, had been in trouble before and had a little bit of experience, not on this scale, but knew enough about the system, were less naive about it to be able to say, I want a lawyer, or had a parent or guardian who was you know, there was someone who had an aunt who was a corrections officer who came in and said, no, let's go. And so just understanding even what was happening there, but it was so critical. And I think that when we started making the film, we always felt like we wanted to not have a narrator. So all of my dad's films before this one have had a sort of voice of God narrator explaining the story. And we came in really feeling like we wanted this story to be told by the people whose lives it was that we were talking about. And so we wanted to avoid that, but understanding that's sometimes you need that. Sometimes you need some help telling the story. And so among the first interviews we filmed actually was Raymond's. And I remember walking out of that, and he did such an incredible job of explaining that what was going through his head, what that process was like. I mean, as Kevin just said just now, like what he was thinking, what the detectives were saying, how that process unfolded. And we walked out of that interview and said, okay, we can do this, and we can do it without a narrator, because we are going to have these voices that can explain this thing that's really, that if the audience doesn't understand, then we've not done our jobs, right? And that's so important. But as you mentioned, we did have this challenge visually of how to tell that part of the story. We now have these incredible narrators who can explain what's going on, but we have no images. Of course, there are videotaped statements, but those, as you said, were taken much later at the very end of this long process. And so we had this challenge, and we don't generally do recreations, like with actors playing roles, but we needed some way to create these spaces. And even though we are very much not set decorators or very experienced in this, we actually turned our Brooklyn office into these 2 interrogation rooms. We found ancient desks and file cabinets, and it was a little, we painted the walls. There was tea bags on the walls to make them look old. I mean, it was like an interesting project, but to try to create these spaces. And we knew what the spaces looked like because there are photographs and from the interrogation, the videos that you see, not interrogation, sorry, the statements. And so to create these spaces, and then we used different kinds of film. So we filmed on film, as we did 16 millimeter, but we also filmed in 8 millimeter, which has a much grainier texture, and we wanted it to feel a little bit like you were in someone's memory. So there's these moments of some cigarette smoke, or you just see this scene, and we were trying to make it a little bit more in the clock. Right, I mean, you have to figure, if you're not gonna have actors, you have to figure out some way to animate it a little bit, so the ticking clock. And even down to the sound design we use. So once we finish the film and we get into the sound mix, our engineer there did work with the sound to essentially help create this feeling of like closing in on you, and how even the sound design can be part of amping up the kind of intensity of that moment, the clock ticking, the sound, and just to kind of try to create some little sense of that atmosphere around the storytelling.
Kevin, did you feel like the visual way it's depicted in the film was it consistent with your experience? It's not obviously the same place, it's not as long, but did it capture the feeling a little bit?
Yes, it captured it, and it put us in this mood that, like, our voices wasn't heard and our story wasn't told, so we was ready to unveil everything right there. So it made us comfortable, even though it was, at the time, it was uncomfortable to let our story out. But if we felt comfortable with Sarah and the crew, so it was fitting.
So I should say, all 5 boys recanted their confessions immediately after they were out of the interrogation process. Saul, if you don't mind, I want to just repeat something you told us last week about how, ironically, an innocent person might feel they have less to fear from talking to the police than somebody who's actually guilty. And so, because they didn't do anything wrong. And I want to just turn to, there's so many lessons we could draw from the case and the film, and I want to ask you what lessons you think we should draw. I mean, there's a lot of narratives here. The one about race, which you tell very powerfully in the book and the film. The one about the way police conduct criminal investigations, especially interrogations. The media's role. What would you like us to take away from this, tragic, terrible experience?
Yeah, you're right. It's a few. Yeah. One I would say is, and it's cliche, but it's the truth. Never judge a book by its cover, because we were 5 individuals that was raised from a nice family background, but the way we was depicted was almost gorilla-looking, animal-like. We were named so many different names that it wasn't us, so, And because of the frenzy in '89, I never blamed the public, because the way that the media did a number on us and for the public, I could see why people probably would have believed that. So you have to take a step back at the time and actually analyze the situation, and just pay attention to what's going on, because it's always two sides of a story. And unfortunately, 30 years later, not much has changed as far as race relations, and these same things are still going on. Even with my mother grew up in the Jim Crow era. She grew up in the South, and she told me stories, and it's not that much different. We're not that much different from the Scottsboro Boys. We're just a modern day version of it. We're not that much different from Emmett Till. The same things are still happening, so I think that people need to be more aware, and like that's my job as well as the brothers now. Before, we didn't really want to speak about these situations because it was so painful, but now it has become our job. It's become our due diligence. Like, we must do this because I have 2 daughters. We all have kids, so now we're carrying that torch. We have to pass on awareness to others. So that's one thing I would tell people, to really just pay attention to the story. There's always 2 sides of it.
Yeah, I think, for us, telling the story was always about understanding who Kevin and the other guys are and their lives and their experiences. But I think the context for it and learning about the sort of what happened and how it happened, to me the lesson is about all these systems that got this wrong. That this is not as simple as a rogue prosecutor or detectives or, corruption or something. Like, that actually is a kind of simpler thing. This is not bad apples. This is systemic, and that we see that in the ways that the interrogations are meant to be conducted. I mean, there are places where these interrogations cross the line, but largely a lot of this stuff is literally by the book, and it causes false confessions, right? And so, and then the way the media buys the police narrative and runs with it, the way the public buys that narrative, that there are all these systems in place that should have been looking to do justice instead of get a conviction, that should have been looking to get to the truth instead of regurgitating this police narrative. And so I think it's really important to see the big picture of how these institutions, I don't even know, with the justice system, it's hard to say whether it failed or whether it was built to do exactly this, but that did not do justice, and that we have to think about that on a really large scale, and to understand, as you said, that this is not an isolated case, that this continues to happen. And so we have to think about the really large scale of how we can make changes in these systems so that we understand how this happens and what we can change so that it won't happen again.
That's great. If I could just add one comment, as Catherine and Professor Upham said, we focus on comparative law, comparative systems, and one thing we've learned through this project is there are police in the world who do a much better job than we do. In the United Kingdom, for example, after a series of scandals over 25 years ago, they changed the way their police conduct interrogations. There has to be a lawyer present. The whole process is videotaped. The police are not allowed to ask even leading questions, let alone, and it's focused on getting information, not focused on getting confession. So I think there's hope for change, but as you said, I know in the preface of your book you said you wanted to find out how did this happen, and I would just change the tense to how does this happen, and how can we fix it. So we're out of time for this segment, and I see
Yes.
Catherine signaling me, so we're
Yes.
gonna.
So what I'd like to do is ask the 2 guests to stay on the stage. We're going to bring on 3 more people. So we're going to bring our Asian colleagues back into the conversation now. So would Chen Yuning and Akiko Kogawara and Lena Zhong please join them on the stage? What we're going to do now is Ira's going to continue the conversation, only now it's a truly transnational conversation, and I don't think we could have fit another person on that stage. But we're going to continue for another 10 minutes, and then we're going to open it up to the floor for questions. So I'm sure you at this point have questions or comments that you want to make. Start to get ready. We have mics on each side of the room, so you'll be able to step up to the mics to ask your questions. But first, I will just carry on the conversation a little bit for another 10 minutes.
Sure. So, thanks. So, as Catherine said, we have about 20 visitors from Asia here for our program. We didn't have time to bring them all up, but we've asked 3 of them to come and tell us a little bit about the work that they're doing in their home country. So, first, I want to just turn to Lina Zhong, who's a professor at Chinese University of Hong Kong, who studies wrongful convictions in People's Republic of China. And Lina, could you just maybe talk a little bit about your work and about what you've learned about wrongful convictions in China in, a minute or two? I'm sorry.
Okay, thank you so much. I'm so honored to be here. And the program is brilliant, I have to say. Aaron did not bribe me for saying that. It's a long story, right? I've tried to collect it like 400 cases so far. I have analyzed 141 violent cases in which the defendants were exonerated by the court. So we try to, we learn from our US colleagues, and we try to look at the so-called contributing factors for the wrongful convictions. And we come up with a series of, counts, and we found that the most salient distributing factors for wrongful convictions in China is false confessions by police torture. Okay. And also there are some other like eyewitness misidentification, police misconduct. But here, I don't have to tell you that here the number one contributing factor is eyewitness misidentification, misidentification, right? So this is a very different. Okay, time's up.
Okay, yeah, maybe could you just briefly tell us about maybe one case, maybe the Shi Xianglin case or another case that kind of grabbed the attention of people in China?
I said my first seed, looking at this was planted in 2005 when I learned from the news that Mr. Ze Xianglin from Hubei province in central China actually was found not guilty, was exonerated because he was convicted of killing his mentally ill wife. But 11 years later, his wife came back to the village alive. Okay, that is a very dramatic case, caught my attention, and I was so shocked, and I would like to know why this had happened. But just 5 years later, a similar case occurred again in Henan province, also in central China, in which a village man, was convicted of killing one of his neighbors. But anyway, it's just 5 years. Some years later, the neighbor came back to the village. So that really was so dramatic, and of course it aroused a lot of outrage in the country. And indeed, after 2010, the country has rolled out a lot of measures, tried to address the issue, but the effect, still remains to be seen.
So thank you. So in both of those cases, even though no crime had actually occurred, both defendants had confessed. And
Yes.
The confession evidence was some of the primary evidence that led to their convictions.
Yes.
So we're not giving this subject enough time, but that's all we can do under the circumstances. I want to turn to Akiko from Japan. She's a professor of criminal law and a key person in the Japan Innocence Project. I should say the Japan Innocence Project also has a sister project that works especially on shaken baby syndrome cases, and Akiko has been involved in that. Could you just tell us a little bit about your work in Japan?
Good morning. I'm Akiko Kogawara from Japan. It's a great honor to be here with you today. And I'm working on shaken baby syndrome cases with lawyers and doctors. And you might have been about shaken baby syndrome theory. This theory says if a baby had 3 symptoms, bleeding in brain and eye and brain swelling, we can say the baby has been abused. But this theory has been questioned, questioned and criticized in the US and many countries other than Japan. But this theory has influenced in Japanese medical community and child welfare, and now interrogation and criminal justice. But we are concerned about there are many cases that parents are wrongfully convicted or accused, and they are mistakenly judged to have committed abuse, and some of them, the parents gave false confessions. And so because of junk science and very coercive interrogation in Japanese criminal system.
How much time do the police have to interrogate a suspect while they're in detention before they're actually charged with a crime?
In Japan, the suspect are in custody for maximum 23 days, 2-3 days, 23 days in very isolated circumstances and without defense lawyers present. So it's very hard.
And in mainland China, how long do the police have to interrogate someone before they're charged?
Officially, it's said 37 days, but according to one of your articles, it's like 7.5 months. But we have in my cases, there involves a lot of so-called long detention. In which the defendants were detained for, even beyond the 7.5 month period.
But I should say in 2012, China amended their criminal procedure law and required videotaping of interrogation in many serious cases. There's still some issues with the implementation, but that was a significant reform. In addition, they passed an exclusionary rule for coerced confessions. Japan, I know, has also recently, in the last few years, adopted rules requiring videotaping. So we're in the middle of somewhat of a reform process. So I think we have time for Q&A. Yeah, I know Yuning has already talked about Taiwan, and so I think we'll open it up for questions. So as Catherine said, there are 2 mics on either side. While we're waiting for people to step up, one of the reasons we're so interested in this topic is, a lot of our law school classes on criminal justice and the constitutional law are all about the procedural protections in our system that we're very proud of. Jury trials, burden of proof on the prosecution, presumption of innocence, right to confront witnesses, a jury system. But these cases that the Innocence Project and others have brought to light have really shown us that these procedural protections are not a guarantee of that we get it right. And so, it's great to be proud of our system, but we also have to be honest about what's wrong with it. So, see, we have a couple of questioners. Sir?
Yeah, first of all, I think you've all done a tremendous service to the world for what you're doing, and for that you should be commended. Ken, I'd like to ask you a question, and perhaps Sarah as well. Excuse me. Throughout the process, what is the one thing, or two things perhaps, that you wish you had said to someone but didn't say or couldn't say?
And I apologize, I should have said this before, but if you could identify yourself and if you have an affiliation, institutional affiliation.
Yeah, I'm in the witness protection per, I can't. No, I'm just a guest of someone. Seth Banks is my name. So what is that? I'll repeat the question. What is the one thing that perhaps you wish you had said that you didn't or couldn't say, or perhaps the one thing you wish you had caught on film when you made the documentary that you wish you had done or didn't do?
Well, I mean, yeah, I mean, I think a lot of what Kevin and the other guys who've now been doing a lot of speaking about in telling their stories, I think a big part of that often is also a sort of know your rights aspect, right? Which is about, and I think that certainly one lesson to be learned is about always asking for a lawyer. But I think that the reality is that when you're talking about children, the expectation that people know what to do in a situation like this is not reasonable. And so certainly education is important, but there is a limit to what we can expect or ask of people to know. And so I think the bigger question then becomes, how do we create a system that protects people who can't possibly be expected to know what their rights are? A system that informs them of their rights, a system that protects them even when they don't know what those are, that provides a lawyer to a juvenile even without them asking for one. And so I think, to me, that's the bigger question, is of how can we change the way that we do things, especially when it comes to juveniles, to create those protections sort of built into the system.
Well, just one quick thing, actually. One thing I wish that, as far as the interrogation process, is that the other detectives would have listened to their fellow colleagues when we were getting physically harmed. Nobody listened to us when we actually told the other ones what's happened. As far as my case, when in the beginning, when I got hit with a police helmet and actually said it was the woman jogger that scratched me, and when I told the detectives that their fellow colleagues did that, they laughed in my face like I was lying. So I wish they would listen more to what happened.
Well, and I would just say, however you look at the interrogations of the case, how could once the DNA evidence came back and excluded all of the 5, how was it that the prosecutors and the police, the DA's office, that were made up of a lot of smart people, the NYPD, a lot of experienced people, how come no one said, wait a second, did we make a terrible mistake? Because the DNA evidence not only exonerated them, but it was inconsistent with with their theory of the case. So I think if you want to go back and say, what could have happened differently, I think you really have to ask that question of the investigators and the DA as well. So actually, I was going to ask you if you ever tried to question the police or the prosecutors for the film.
We reached out, and at that point, the civil case was still ongoing, and so they had been advised not to talk to the media at all. And so no one involved in the case on the prosecution side or the police would talk to us. But yeah, absolutely. I mean, I think that there is this really clear moment where even if you can understand sort of in the immediate reaction to discovering that this crime has occurred, the sort of, I mean, it's a huge problem to begin with, a kind of jumping to conclusions about what happened, but you can understand that you would say, these people were in this same area, and this is something we want to ask them about. But to go from that, and then you get these statements that even before the DNA evidence is available, the statements themselves disagree within themselves. I mean, they disagree with themselves, they disagree with each other, they disagree with the evidence that they're starting to gather. Once the jogger wakes up, they're able, she's in a coma for 10 days at least. Once she wakes up, and she has no memory of the attack, but she is able to piece together sort of where she jogs, and her neighbor knows what time she left and stuff like that. And so there's already evidence coming in. And then you get, later that year, this is August now, you get these DNA tests, and they called them inconclusive, but really they still excluded, they weren't strong enough necessarily to make a match, but they were strong enough to exclude not only the 5 who were accused, but all the other kids who'd been in the park and had been interrogated whose DNA they tested, right? And so at that is this opportunity, this moment to say, wait a second, to take a step back and say, did we get this right? And there's a book by a guy who worked in the DA's office at that time and was kind of their DNA guy, named Harlan Levy, who wrote this book called And the Blood Cried Out, which is about all these different DNA cases he worked on at the time. And there's one chapter about this case where he talks about Elizabeth Lederer, the prosecutor, coming in and saying, I feel like I've been kicked in the stomach, that because they've gotten these DNA tests back and it doesn't give them the evidence they thought it would. In fact, it doesn't match. But and then they just move on. It's like, well, this is going to make it harder for us to try our case. And the huge irony of this book is that there's also a chapter about Matias Reyes, who is the actual perpetrator in this case. This is long before they knew that when this book was published, they knew he was the perpetrator. And that's a chapter about how they successfully used DNA in matching him to these other crimes. It's the same people, the same office, they're working on the same things. If they had thought even for a second in that moment, maybe we got this wrong, they literally could have walked that DNA sample or the result of that test across the hall and realized that there was a match. But they weren't looking for it because they were so set in their assumptions that they weren't interested in that.
And I just want to add to that. One thing I take away from this case, especially as a former prosecutor, is the tremendous power that individual police, individual detectives have in an interrogation context. And that you can use that power to get a confession, and the techniques that they were trained to use are very effective. But we know that the confessions that are obtained through those tactics, through exercising that power, are often false. And so it's incumbent upon the people who do investigations to use their power more wisely and to learn about how, even unintentionally, they can use that power to obtain false information, inaccurate information. And it's incumbent upon them to make sure that in the questioning process, they're not putting so much pressure on the suspect that they'll tell them anything they want to hear. Because that's what happens when people are under that much intense pressure.
Hi, my name is Sonali Chakravarti, and I'm a professor at Wesleyan University, and I'm a scholar of juries. And I've been thinking about how to make jurors more open to thinking about the possibility of false confessions. And I'm curious what the panelists have to say, especially because I know in Japan they're trying to incorporate lay people into the criminal justice system.
So that's a great question. I can maybe take this, so in the United States now, many courts permit expert witnesses like Professor Kaslan and others who study false confessions to testify. And this is a field where social science, I would say with great thanks to Saul, has advanced. We know a lot about the process of interrogation. We know a lot about what are some of the red flags of false confessions. And with more and more videotaping, we'll have more and more data. So that's one thing. Juries can at least hear from an expert, who can counter what would otherwise be kind of your common sense conclusion that why would an innocent person confess? But I think what Kevin and Sarah are doing, and others, in publicizing these cases, we have to, I think, Kevin, you used the phrase influence the culture. People have to be educated so that we can use our experience and our logic to understand that just because somebody said something in a stressful situation, it doesn't mean they were telling the truth. But I don't know, does anybody want to add anything else about jurors? How do we,
Hi, Priya Chaudhary. I'm a criminal defense lawyer here in the city. Your earlier statements about and how Taiwan, you've convinced them to do fully videotaped interrogations is just incredible and really impressive. And I've had the opportunity to witness Scotland Yard do a double-blind photo show-up, and that is a totally different experience than what happens in America. I'm wondering if in all of your research and experience you have seen any countries that have actually done away with interrogations completely and just use investigation in order to try to make a case or solve a crime.
So, I mean, I haven't heard of that. You know, we, in our program for the last 4 years, we've been fortunate. We've had Andy Griffiths, who is a retired detective from the United Kingdom, come talk to us. And we've also brought him to China and Japan. Andy's last job before he retired was training the investigators in the UK in how to do interrogations, or what they call interviews, under their system, which is called the Peace Method. And as I mentioned before, it's not about getting confessions, so the whole point of it and the point of the training is very different from the way most of police in the United States are trained. The suspect, the person being questioned, has an attorney present, the whole process is videotaped, and the police are literally not allowed to ask a leading question, even just a leading question, you know. They're certainly not allowed to lie about the evidence, which is a big problem in a lot of these cases. It was a problem in the interrogations. You know, our courts, on the theory that someone should be able to correct a lie if they hear it from the police, allow our police to lie. So in the UK, they're not allowed to lie. They're not allowed to say, you're lying, tell me the truth, do that kind of confrontational question. And they've been doing this for 25 years. They seem to still be able to successfully investigate crimes. And they haven't had a false confession, at least a reported false confession that we know about in those 25 years. And it's not because they're better than we are. They had this problem 25 years ago, but they took steps to correct it. If I could just tell one brief anecdote, sometimes the work that we do has unintended consequences. So we invited Andy Griffiths to come with us to China with Andy Schaefer, who teaches here. And Andy Schaefer was at the time the legal counsel to the NYPD. And so as a result of that, Andy Schaefer invited Andy Griffiths to come give some lectures to the NYPD about interrogation, and they're still talking about possible training programs. So, but as far as like no interrogations, I haven't heard of that anywhere.
Is anyone else on the panel?
Now here, you know, a lot of people from other countries, when they know our Miranda warnings, and they believe that we must have lawyers present when the suspects are interrogated. So when we've had groups from Japan come visit, they're quite surprised that when a suspect says, I want a lawyer, or I don't want to talk, that the police have to stop the interrogation. So we do have examples where there are no confession cases. And in China, more recently, confessions have been so prevalent that it's actually making news now when they have a case where there's no confession. So look at the next question. Oh, I'm sorry.
Hi, I'm a visiting scholar of USALI. I'm also a prosecutor from Taiwan. And I want to say thank you first for the Central Park 5 movies. It's really good, and I was really touched and inspired by the movie. So I want to say thank you. And my question is for Kevin. After you confessed to the police, and the police took you to be interrogated by the prosecutor, and that part of interrogation was recorded. And I wonder whether you know you were videotaped during that part, during the interrogation by the prosecutor. And had you ever thought of like telling the prosecutor that you were actually not the perpetrator? I don't know, which probably could make the story different. I don't know, because well, I'm the prosecutor, so I want to know that. What do you think at that time, like being interrogated by the prosecutor? Thank you.
Well, yeah, for 3 days I was trying to tell him that I wasn't the person, but I knew I was getting videotaped, but at that age, I don't think I fully understand what was happening, that I was just in a whole confusion of things happening, because it was a process from the 19th to the 22nd of being interrogated, going from different 3 precincts, central booking, then the written statement, then the video confession, and that was the ending of everything. And by that time, I really didn't even know where I was at, you know. But the detectives, they try to put, if you look at the video confessions, you see our parents there. But that was the ending of everything. They didn't show what happened before that, those 3 days. So by that time, our parents was there, and everybody was so confused. Everything was done already. I know with me, my father was there, but he wasn't there from the beginning. So he was there when I was doing the confession, and he seen what was on the video confession, but everything was already signed, the papers, everything was done. So, but I've been trying to tell him since April 19th that nothing, I was not a part of it, but it didn't matter at the time.
I think the really important thing to know about those, by the time those videotapes start rolling, is that I wouldn't even call that an interrogation. That is, as Kevin said, at the end of this long process when, in the hopes of being able to go home, it comes to seem like giving this statement is your way out of a terrible situation because of those pressures, because of the way the interrogation has happened. And so by the time they sat down to do the videotaped statement, this was a belief that telling these lies was a way out. Of course it wasn't, but this was sort of no longer part of the interrogation process. And Saul has something to say, and he's the best person to talk about this.
I think it's important to realize the videotape gives the impression that this is Kevin's opportunity, one-on-one with the district attorney, to tell his side of the story. In fact, what you don't realize necessarily is sitting in the same room while he's telling that story are the detectives who pressured him up to that moment. They're there to enforce his statement. He had a deal, they had a deal. He had been through hours and hours of denial of protesting his innocence, and the detectives who pressured him to go into that DA's office for that statement were sitting in the room at that time. This wasn't an opportunity one-on-one with the DA to tell his side of the story. And that's the way the process has been in New York City ever since.
Thanks.
Hi, this is Dee, a PhD candidate of sociology at Wisconsin-Madison. Thank you for the wonderful panel. I'm curious about how do you think of your work in terms of as a part of a larger social movement, civil society building, because from like Black Panther to the White Terror era in Taiwan to the 709 human rights lawyer arrest in China, that I feel like the similar technique, the coercive technique are used against activists, progressive force. So I'm curious, how do you think about like your work in terms of mobilizing lawyers, in terms of building a stronger civil society? Thank you.
Is your question for anyone specific or anyone?
If I could, I want to ask all 4 different regions and countries.
Whoever wants to Well, I'll just say the Innocence Movement, which has been sort of spearheaded by the Innocence Project, is spreading kind of around the world. It's focused, there are many aspects to it. I think there is a social justice aspect to it, and since a lot of the work that's been done is in the US, a lot of the social justice work is focused on the problems in our society, especially racism, institutional racism, how it affects the criminal justice system. So I'm not sure about how these cases relate to sort of broader social movements in Asia. I don't know, Yuning, if you want to speak to that, or about Taiwan, or in some ways, in China, the criminal justice system for what I would call non-political or not crimes is kind of walled off from the system for politically sensitive cases. So, whereas there's been a lot of progress on criminal justice process and investigative techniques for non-political crimes, when the party has been feels threatened by dissidents, a lot of those reforms go out the window. And, again, we're getting a little bit too China specific, but as you know, last year China passed a National Supervision Commission law, which actually expands the powers of investigators in corruption cases and other cases. So I'd like to say there's like one linear trend towards greater protection of rights, but actually it's more complicated. So anybody else, or should we go to the next question? Yes, please.
Thank you. Thank you for an interesting question, and thank you for first question about Japanese lay Saiban system. And so, what I can say is only about child abuse cases, and especially in shaken baby cases, we need many doctors from many different areas. So like pathologists, radiologists, or pediatricians, or eye doctors, so many things. So even for judges, expert judges and prosecutors, it is so difficult to understand such scientific evidences. So for lay judges, it is it is harder to understand. So sometimes witnesses for prosecution, they gave emotional expressions, simple expressions. Sometimes it works. And the social attitude toward child abuse also affect their judgment. But it's my opinion. And about coercive interrogation, I know one case, shaken baby cases, police officers showed the parents the picture of their critically injured child, and looked the reaction of the parents, and left and imitated their son's voice and said, "You did it, you did it." And in many cases, in shaken baby cases, parents sometimes think they should have been more careful not to cause accidents. So they have feelings of guilt. So such factors is very unique to shaken baby syndrome. So it is such factors. Such factors make in shaken baby syndrome cases, the problem is bigger than other cases, I think. Thank you.
Hi, I'm Jerry Banks. I'm a clinical psychologist. And I just want to take a little different perspective here because it seems that we live in a world where so many group processes work in terms of bias and loyalties and peer pressure. And you talked about training, and it seems to me that the training needs to go beyond just the interrogation process and how to do it, but how to proceed from there. And in particular, when I think of the whistleblowers now that are going on and what's occurred to them, having some way or safe process for individuals, even within this group dealing with Kevin, that if someone wanted to step up and say something and this wasn't right, is there a way to train people or have safe places for them to go where they can also receive some collaboration or security or safety? Because it just seems that's an important component to this as well. And wondering what your thoughts are on that.
When I handle that, or I don't know, Maddie or anybody from the Innocence Project, I think your question goes to kind of something outside the criminal justice system. We're really bad at providing the kind of services that people need, either post-exoneration or when they're in the middle of the process. I think it's a great question. And it's something we've discovered in our conversations with our colleagues from Asia, maybe with the exception of Taiwan, with the Innocence Project pays a lot of attention to exonerees, but that's a private, nonprofit social group. The government in all our countries isn't very good at providing that kind of.
I'm saying also within like the police department or within some other
I wonder if in other countries, I don't think we do it as well as we might in the U.S. to let people inside police departments, prosecutors, defense, within the system. What are the channels? Are there ways in any of the other countries, really, where individual police or investigators can step back and say, it doesn't sound right to me. Look again, when the DNA came back and Harlan or someone said it didn't match. What is a way to make people feel safe in the government process?
That's what I was talking about.
To do something different. And I wonder if in Taiwan or Japan or China, any of the three of you have examples of letting how government officials can step up and say, what's happening here does not seem right to us. I think that's the question.
Okay, thank you.
Yeah, Susan.
Yeah, does anybody have an answer?
I think I can answer to that. In Taiwan, I think after the exoneration of Zheng Xinze, I'm not sure if I mentioned it. The retrial motion was brought by the prosecutor, and after we learned that the prosecutor brought the retrial, we sent a joint brief to the court. So it's a contributory factor in pushing the court to open this case. And right after the prosecutor petitioned for the retrial, we received a phone call from Attorney General saying that I'm doing this. And this is the first time in Taiwan judicial history that a prosecutor petitioned for a retrial for a death row inmate. And it turns out to be a very successful corroboration between the defense attorney and the prosecutor. So after the case, I think there is a very benign relationship that has been formed between at least our project and the prosecutor's office, that this is something that we should do together. And we're not shifting blames, saying that who should be the major causes of this tragedy. And in this year's annual conference in Taiwan, we invite the prosecutor who petitioned the retrial for Zheng Xinze to be the keynote speaker, explaining the process of her realizing that Zheng Xinze is innocent and how she handled the pressure of the victim's family and how she did all the investigation before filing the retrial for him. And I think this whole process is very helpful to form a kind of atmosphere, at least within Taiwan, that this is something that we can do together.
It's a great idea.
Thank you. What I've learned through this program is in the US there is a wide network and data collection to prevent injustice. But in Japan, we don't have such network and many organizations. So as you did, sharing stories with public is very important in Japan. But we are in Japan, but we are not. We are just at the beginning.
I just look at the experience in China. Just take the example of videotaping of interrogation, the interrogation process. This has experienced a huge resistance from the police. Even nowadays, we still have not figured out how to suppress the evidence collected through torture or other physical means. Okay, so there is a saying that if you hear, when I have in the past 2 weeks, I've got the impression that the bureaucratic inertia is everywhere. Everybody don't want to change the old way of life. Okay, so we must have firstly, we have to raise the awareness among the law enforcement officials that problems do exist. Just like when Professor Saul Kassan was giving us the talk, we asked him questions how, it's brilliant. How are you going to educate the police officers? And also, how are we going to educate the law students who will be our future prosecutors, our future judges, right? So the same issue occur, we have the same issue in mainland China.
Okay, we have time for one last question, and then we're going to do the sum up.
Yeah, I'm Susan Finder from the School of Transnational Law in Shenzhen. I want to ask about plea bargaining or insider info on the mainland. I'm not sure whether Taiwan or Japan has something similar, which seems to me has a huge impact on false convictions and whether, and unfortunately, it's a reform that mainland China has adopted. So, comments from people on plea bargaining and yeah.
Actually, we don't, in the past, we don't use the term plea bargaining, as I understand. Yes, let me. But in reality, we do have it, because we have a famous saying, lenience to those who confess, and harshness to...
Severity to those who resist.
Yes, that's really, it's one way or another similar to plea bargaining, right? But from last year, as I remember, we have introduced something very similar to our plea bargaining system. It's like if you, in minor cases, you can have agreements with the prosecutors, and then, it will be just like our guilty plea. If you plead guilty, then your case will be processed quickly, and then the penalty may be reduced, but how far this can go, we have doubts. Even my lawyer, my friends, the defense lawyer, Dr. Warren also, have been, we have been discussing this. We have seen so much about the about the so-called disadvantage or weaknesses of the pre-bargaining system in this country. But now we are rolling out the same thing. So we are trying to, we're interested in what will happen.
Okay. Well, I think we could continue this conversation for a long time, but we're out of time. I just want to thank all of our panelists for this discussion.
Thank you very much. So we knew that today we would be bringing up a lot of issues we wouldn't finish discussing because in part we're talking about different systems, and so some ideas would be picked up and then not completely wrapped up. But so it goes with a limited time period. We asked Professor Rachel Barco to help us try to pull these strands together because we thought that if anybody could do this masterfully, you could help us make sense of what we've been hearing and then give us maybe some ideas or some thoughts for as we leave here going forward what we should be focusing on. Thank you.
Thank you. This is a tough act to follow, let me just say. So what I think I'm going to do is not really follow it so much as summarize it. And so what I would like to do is just start by saying that these cases of innocence are canaries in the coal mine for things that ail the criminal justice system overall. So these are things that are happening everywhere and to everybody. And it's these cases, though, tend to be really good for drawing attention to the issues because they are so sympathetic, right? There's no one that wants to see this happen. And so they end up being the perfect vehicles to shine a light on problems that are sometimes hard to get attention to when they involve people who have committed crimes or bigger systemic problems. And so I thought I would just identify a few of the things that have come up and some of the things that we could think about and how it would, would benefit all of us to fix some of these problems. So one, if we think about some of the things that have been mentioned today that cause these problems, we know mistaken identification is a problem for people, and we can do things to fix that. We can think about changing lineup practices. We can have double blind where people don't know who the suspects are, to make it so it's less likely that biases are kind of subconsciously filtering in. We know false confessions are an enormous problem, and there's so many things we can do to try to address that, from thinking about what kinds of coercive pressures police officers are putting forth in their interrogation practices and fixing those, for making sure people aren't detained pre-trial, so they'll say anything just to get out of jail because they don't want to be there. We can change the kinds of offers that we would allow prosecutors to make to people if they would just plead guilty, but they face penalties if they go to trial and they try to fight for their innocence. So we could think about forensic science in a lot of cases is a problem, where there's junk science is used to convict people who are innocent, and again, it's going to be pervasive in lots of cases involving junk science. So we could have better standards for the science that we use. We can have labs that are independent of the police and the prosecutor's offices because they all work together in some places, and that creates bias. Another cause for wrongful convictions. We know there's false accusations, people perjure themselves. We can think about what makes people do that. What kind of pressure are police officers putting on people or prosecutors so that they will say that someone else did something? And we know there's misconduct by police, by prosecutors. And we could look to see what causes that. What causes people to feel like they should hide evidence that shows someone's actually innocent, or to cut corners to try to pursue that conviction. What causes that to happen? And we could think about media pressure and the way the media covers so many of these cases and how that affects these public officials and the pressure that they feel, the kind of training that they get, and the approach that they take to these cases, the implicit biases that affect all of these actors as they're going through it, and that's going to vary by country in terms of the kind of biases people may have with targeted populations. Certainly here in the United States, though, we see implicit racial bias in the way that all this information gets filtered by police officers, by prosecutors, who they focus on, how they interpret what they're hearing. It's all done through a lens that is going to be infected by that. And we could think about how you de-bias, how you put in checks and measures in place. So in other spaces in life, when horrible things happen, when in the medical community, for example, when there's malpractice, when someone dies in the operating room, in the military, when there's something goes wrong with a piece of equipment, that's a moment where in those organizations, everybody stops and does a sentinel review and says, how did this happen? How did we screw up? And how could we prevent it from ever happening again? And that's what we need to demand in the context of every single one of these exonerations, because it's not like, oh, that was one case and whew, good thing that doesn't happen often. These should be moments where we do a sentinel review and we really ask, where are these deeper systemic problems? And how can we better protect it so it doesn't happen again? And then the last thing I just wanted to say and sum up is just the other thing that inadvertently this creates, and I know that you don't sign up for this, but the messengers for this reform, people who have been exonerated, are the most powerful messengers I have ever heard from. And I just want to thank you so much for speaking out, Kevin, on these issues, because those are the voices that I think are heard more loudly and more clearly by everyone than anyone else, more so than academics, certainly, but even more so than law enforcement. You know, you need the powerful voice on the other side to change the narrative. And I do think we're seeing that. And the movement, the innocence movement, the lawyers working on it, the academics, all of you here, the pro bono lawyers who are participating in Taiwan and in other places, you know, it actually starts to create an army of people who see this firsthand and see how awful things are and are really fighting for reform. And so it does give me some hope that we will get some of these processes changed. So I basically just want to close by thanking all of you today for teaching me more about how this works in various places and for allowing me to sum up and be a part of it. So thanks, everybody.
So I'll just add my final thanks to everybody who's participated in today's program. Each one of you could have spoken to us solo for the whole morning, and we would have learned so much more if we had had the time. But these contributions have, I think, come together to give us a picture of a global problem, of a human problem that will eventually yield itself to a human solution, that perhaps by acting together across borders and sharing experiences and science that we all do in our own jurisdictions, perhaps we can move forward. And I agree with one of the last thoughts that Professor Barco made, that sometimes when we feel a little discouraged about progress or backsliding in one country, when we look across at another place that has had progress, we can be inspired by that. And I hope you all have shared in my sense of being inspired this morning by what our speakers have brought to us. So if everybody will join me in a final thanks to everybody, and thank you all for coming.